Good afternoon. Welcome back to the B&H virtual event space. It's everybody's favorite time when the event space turns into the Jack and Ed show. Everybody's favorite dynamic duo, Jack, Ed. What's going on, fellas?
Well, I got a meeting in about a minute with a beach, but I'll spend some time with you guys.
Jack.
Oh,
Jack's
such a
over.
nice guy. Such a nice guy.
I look forward to this time. It doesn't happen nearly enough. As everyone knows, if you don't know, you're in for a wonderful hour. We're going to get some information sprinkled in. A lot of antics, a lot of hilarity will ensue. But if you guys do have any questions, anything copyright related, legal, get it in. We'll see if we can get it answered. But I'm going to get out of here. I'm going to come back in a little bit for some Q&A. I'm going to start my hobby now.
I think you need a hobby.
I think I need one. I need a bigger fish tank is what I got this little struggling excuse for a fish tank back here. You got the majestic one behind you there, Ed. But look, I'm going to turn it over to you guys. A wonderful hour is ahead, and I'll see you guys in a bit for some Q&A.
Thanks a lot, Derek. Appreciate it.
Does he really have to come back?
No,
yes.
Not at all.
Okay.
Somebody has to wrangle us. Let me get my share going, and I'll start on our keynote. So this is it, number 16, Ed. We've done 16 of these, more than just copyright, Q&A&Q. Hopefully people have questions for us. Some of the things we're going to go over today are true tales from Ed's overflowing vault of tales. Good business things, basically, to do. We're going to talk about a bunch of AI things, especially some suits that are being filed against AI companies. Today, it's about the first half of our presentation is going to be really about business. The second half will cover a lot of the AI things. And of course, some other court cases that we think photographers are interested in. To start, this is our email. If people, we always present this. And just to point, some people get confused. Ed's the lawyer, I'm the photographer. And I just want to start with just a little plug for myself. I was, in October, I was at the U.S. Patent and Trademark Office at their Global Intellectual Property Academy, international seminar on copyright. And I was asked to sit on two panels consisting of various artists, authors, songwriters, graphic artists, and of course, I was there for photographers. And it was very interesting. A lot of the discussion had to do with AI, but it was really about going over copyright, a lot of international concerns about copyright. The attendees were from every country around. That was the interesting part. They were all ministers and lawyers. And there were some really good discussions. There were also from the Copyright Office and variety of different government agencies. I do want to point out we do have, it's been a while, we don't put a lot on our blog, thecopyrightzone.com, but we have two very good articles we just put up recently, and they have to do with dealing with things that why lawyers may not want to hire you and things for. The first article is called When Silence is Golden. And as it starts with that great quote by Mark Twain, it's better to keep your mouth shut and appear stupid than open it and remove all doubt. I'm not going to touch that right now and say anything more. The other article we have is just more lawyer-client relationships. Some of the stuff we talk about those two articles. This is from the blog post. One of the things is how to and not to present yourself. People think that you go to a lawyer, they're just going to hire you. But Ed especially, I know, doesn't take everybody that comes through the door.
Well, both articles deal with when you're hiring an attorney. And we've done articles, and it's in our book, about how to choose an attorney. But don't assume that every attorney wants your case. Don't assume you have a case. And as we have said often, as you're interviewing the attorney's interviewing you. So some of these are do's and don'ts and D's and Dems as to whether or not the attorney would represent you, wants to represent you, or whether you want the attorney to represent you.
One of the things we also talk about is the headline, I'll gladly pay you Tuesday for a hamburger today, also known as working on contingency. A lot of the posts I see online, people are saying, oh, call a lawyer and you can just do it. You'll pay them. That doesn't happen that often. Do you want to say anything about contingency?
Well, sure. First of all, if you're the one being sued, there's no such thing as a contingency fee. So if someone's suing you, there's no possible way that an attorney could work on a contingency fee. Secondly, the overwhelming majority of attorneys in this field work for companies and do defense work. So the few who represent creatives, if they are going to work on a contingency or a partial contingency, which we do frequently, they have to be assured to the best of their ability and experience that you are a good client to represent and that you have a case that's likely to make them money.
So being a lawyer is you're a business, basically. You have to make a living.
No lawyer that I know does this kind of work for fun.
Here's something else we discuss, and we go more into that in the article if you go to it. Writing a do-it-yourself demand letter can have severe consequences that can severely bite you in your consequences. Something that been going over and over, and I see this online all. Somebody gets infringed, and people saying, "Well, send a demand letter, send them a bill, tell them that they owe you X amount of money," and
never.
Keep trying to tell people, do not do that. It will create many problems for you later if you find out you're going to be suing somebody.
Frequently, I'll get a call from someone who has a case, and it's a relatively small case, and I will, in effect, dictate a letter for the client to send, not on legal stationery, that simply says, in effect, I want to be paid by X date. I'm copying my attorney below. And if I don't get paid by X date, then I'm going to refer it to my attorney, period. That's all you say. That's it. But you have to do that in conjunction with an attorney. The attorney's not writing a letter, he's just dictating 4 sentences to you.
And I'm just trying to see if there's any questions coming up. That's why I'm going in and out a little bit here.
So when the post here says can have severe consequences, it's very common where we'll have a case where the potential client will have written a letter and say something like, if you pay me $10,000, I'll be fine. I'll go away. And they don't realize that they have a case that's worth $100,000.
Yeah.
So later on, when they have to sue, that letter is going to be used against them. According to the law, it's not binding, but according to judges and juries, it makes the attorney look like a pig. That the only reason that they're in court is because they wouldn't pay 10. Okay, now we'll pay 10. What, does the attorney get the rest? So it devalues your case. These letters are always, without exception, written by clients who do not know the value of their own cases, without exception. In 45 years, I've never had a client who knew the rough value at litigation of their case, ever, not once.
Yeah, and in just shorthand, what it means is you send out a letter saying you owe me $1,500, and then suddenly you find out it's worth $30,000, $40,000, $50,000. They go to court and they show the initial letter to the judge saying, well, you asked for $1,500. Why are you in here now asking for $50,000? What changed? And yeah, the judge is not going to be looking kindly on you, is figuring that you're just in there for a killing and wasting his time.
Let me use a real good example. We represent a lot of medical illustrators, and the medical illustrators tend to have not one, but two degrees and spend 7 or 8 years of higher education. They have very scientific minds. They don't think, if you will, like regular illustrators. They're more business oriented. We have a case where there are 500 plus infringements. Do you think that that medical illustrator, with all the degrees that he or she has in science and studying autopsies and working with doctors and lawyers, wrote his own letter to the big company that is 500 infringements? Would any of you listening write your own letter if you were infringed 500 times? Well, there's no difference between being infringed 500 times or once.
Well, I think we've covered this one pretty well. One of the other things is just answer the questions asked. And for those people who remember Dragnet, just like Joe Friday used to say in the old TV show, just the facts. What we've seen people do is they start over explaining. They start talking about things that really aren't relevant. And you just want to be there. If a question is asked, just answer the questions. It's one of the things as an expert witness I've learned a long time ago. When some question, if I can answer it with yes, that's what I answer it with. I do not tell. Just answer the questions asked.
Example, yesterday I took Richie, our dog, to the veterinarian, and I gave her just the facts. And if she wanted to know more, she asked. So if I need to know the color of your car, I'll ask. You can just tell me I was driving my car when this, that, and the other thing happened. If I need to know the color, make, and model, I'll ask.
Yeah. So, this is an important one. Bring any and all papers, emails, photos, videos, invoices, copyright, anything you have, especially on paper, to the lawyer when you're going to hire a lawyer.
Cannot stress this enough. We have a case where our client has a contract, a physical contract dated 1984, no pun intended, and none of the other people that are going to get sued has a copy. Now, testimony in court is very important, but documents always trump, no pun intended, testimony. So we dangle a contract that's dated 1984 from an old typewriter. It says what it says. What anybody wants to say has happened over the last 40 years is not going to sway a jury the way a person who maintains all of their records for nearly 50 years and can take it out and say, I keep everything.
Yeah, well, we're going to go a little more. Let me move on to this one. These are just true tales, because everybody likes to hear things, not just hypothetical, but things that really did happen. And Ed is a constant source to me. He's constantly calling me, telling me, you can't believe this one. And he changes the facts. So I don't know who anybody is or what the actual situation is, but I get the stories. So these are stories we couldn't, even if we tried. And this was the best I could come up with a heads on some of these, because that's the way Ed usually feels on some of these stories that come in.
Which after 45 years, you think I'd be used to it, but it's still, and my wife constantly says, aren't you used to this already? Why do you get so aggravated? And I say, because I see $100 bills just flying out the window, lots of them.
So on, we call that list. Ed is a commercial case for when another legal issue around pension comes up. Ed gives strict instructions to the client. Ed says, I don't know anything about this pension issue. I do know a lawyer who does know everything about this stuff. This lawyer has been doing only pension cases for 39 years. Obviously, he's a specialist. Call him, do whatever he says. pretty simple instruction, great connection, some with, a specialist. This is what you want on these issues. So guess what happens? Client spoke with mother's lawyer's paralegal. He worked on a pension case when he was in law school. He told me what to do, and I did it. I said, okay, did you call my guy? Client, no, didn't have to. The paralegal gave me the answers, and I did what he said. Ed, what was the result of this?
She/he is going to lose many thousands of dollars. And if she lives to be 85, it'll be a miracle because she'll be the stress of having to pay what she's going to owe. And this is a client now that I would not accept another case from, because if the client's not going to listen to me, she might as well take the money that she's paying me and go to the casino.
Yeah, we've gone over many times on the things we've written in our book, saying do not neighbor's cousin's son who just got out of law school on some of these issues. And when people say, oh, hire a lawyer, we always say make sure you who is in the issues that you need. Not every lawyer will do it. It's like a mechanic. If you need an airplane mechanic, you're not going to go to somebody who deals with cars. You're going to deal with somebody who understands the issues that you have, and it's the same.
Perfect example. I have to work my car into everything. I drive a 1968 Cougar. My mechanic retired. I called another place and I said, I have a 1968 Cougar. Would you work on it? He says, absolutely not. We don't work on any car that's made before the year 2000. Fine. Okay. Perfect. I don't go to him.
So let's go on. Here's another tale. And this one is the client refuses to pay photographer, which is a story we've heard many, many times. But in this particular case, the client said that they would have paid something, but blabbed about the situation on social media. Something else I talk a lot about. They said, we're not paying. You libeled my company on various social media sites, so sue me, and then I will sue you back. We emphasize over and over again, many companies know to put their company name something called Google Alert, and Google Alert lets them know if you're saying something, or they will just go after. They have an issue, they know to look at your social media. The photographer told Ed, sometimes the emotional aspect can lead to significant mistakes, as in my case, when I waited too long, or equally, when we emotionally shared the situation on social media without considering the consequences. And Ed, what did he mean by I waited too long?
So cutting through the psychobabble, this prospective client didn't do anything of a legal nature for over 10 years. So therefore, every legal case of every kind has a time period known as a statute of limitations, within which time you must sue. And this client's ability to sue had expired, about 5 years earlier, or 5 years before he or she called me. And as far as the emotional impact, I'm sorry, I'm not that sympathetic in commercial cases. This is just my opinion. I've handled divorces and custody battles, which are very, very emotional and very terrible, and I get it. But here, when you're talking about getting paid on a copyright case or someone stolen your imagery, I understand that there's emotion involved, but let's not overdo it to the point of paralyzing yourself over calling an attorney.
Well, I think what happens is when it actually happens, if somebody is busy working and whatnot, they're going, I'll just let this go. I don't want to deal with it now. And I think what Ed and I are both seeing, especially in the last couple of years, as some of the businesses get slower and slower with photographers, they're looking back on things, money, and saying, oh, I had this case from way back when. They don't realize that, yeah, if you don't deal with it, there's a few limitations. You're going to be able
The number of calls that I've gotten over the last year where they've waited too long have, I would say, tripled over the same types of calls that I was receiving 10 years ago. Because photographers are using litigation to make money because work is not there.
yeah. So if you have one of these issues, deal with it. Don't put it off. Don't say, I just don't want to deal with it. I'm too busy right now. You to contact a lawyer and have somebody else deal with it. That's what I found out. So moving on. Two tails of paper. Ed has always said, and we've repeated this over and over, never throw paper because you backed it up or have a copy on a computer. There's certain pieces of that you want to hang on to, model releases, and especially original invoices have your usage, how you are allowing your image to be used. This was a story that happened. Ed, 4 people signed an agreement in 1984 for 3 people. Contract lost all meaning by 2005. Didn't mean anything anymore. It went on, but he needed a copy desperately for a pension plan. Now the other parties threw him out. So you them saying, "Do you have a copy?" The original and accountant for this photographer are both long dead, and the document is not filed with any government agency, nor did it have to be. It was just something he needed to have. And the one quote that I like that the person told Ed was, "Oh, that my record of that was gone computers ago," which issue with not keeping paper. If keeping it digitally, and we've gone over several cases where things like this happened, because it's on a computer doesn't mean that you're going to have it. I mean, I still have, I finally, just a few months ago, got rid of my last zip disks because I have nothing to read them on. And this issue, Ed had a story a while ago. This wasn't in this article, about somebody, a case you had in court where you found out that the electronic copy of the terms and conditions were changed over the years.
They were.
So the original, they weren't the original ones that were on paper. And that was a problem in court. That threw out everything. If
the client basically had no idea at what points in time he made changes to his terms and conditions. And each time he had a new set of terms and conditions, he, in effect, threw out or deleted all of his former invoices, except the front of the invoices that showed how much money he got paid. Now, why someone would do that is absolutely beyond me. It's just plain dumb. In this case, Jack, is there another slide on this case about the?
Yes, there is.
Okay,
there is.
go to the next one.
Oops. So
Yeah.
failed by personnel for the it will cost about $5,000 in accounting fees, along with thousands of additional dollars.
Yeah, what's going to happen in effect is, since nobody has this agreement, the accountant is going to have to establish through almost like a lawyer that it existed and this is what it contained. At which point the IRS may or may not believe him. And if the IRS, in effect, doesn't believe him, the client is going to get slammed. Absolutely. The other 3 people had left the business, and what happened 18 years ago had no effect on them. They cashed out their mini pensions 18 years ago. My guy's the only guy who stayed in the business. So he's got 18 years of income related to his pension, which is going to have to be established somehow as what their pension plan was.
Yeah, and that can be a huge, huge problem. On the same day that this was, he had another client his written contract from 1984 that he kept the paper from 1984. And Ed said they started to settle in 24 hours, and that client is going to get paid a lot of money, perhaps a small fortune, as Ed said, basically because they held on to the paperwork. They were able to prove what their usage, what their contract was.
What creatives don't understand is you have to assume that every business is going to be sold. Twitter was sold. Mark Cuban is selling the Dallas Mavericks. Businesses buying businesses mega size happen every single day. In connection with the buying, selling, and assigning of rights in businesses, papers get lost, attorneys screw up, attorneys die, accountants die, and you have to assume that you're going to be the last person standing with proof. And our client has the original contract, and the defendants were not the original parties. They bought the business. So
Well,
they're stuck.
I have a barn full of my old paperwork from my studio, and I will tell you, it's fun to go through sometimes to see some of the old jobs and jog some of the memory of things that I. So,
And you can do, for the younger photographers, you can do an autopsy, what I call an autopsy. Take a look at a job and determine if you really did make money. And if you made money on that job, how did you make the money? And if you lost money, even though the invoice looks like a big number, do an autopsy and say, gee, I charged this client $60,000 for this job, but I lost $8,000.
well, I also tell people to do that. Tell people to do that. Some of my friends, when they say business is really slow, I said, go through your old, see if there's a client that you worked with that you haven't contacted time that you want to contact again. And that sort of gets people moving, and they do get work from that. This is, I think, the last one in this series, and then we can go on to some AI stuff. Photographer calls Ed's office, claims an infringement, and wants to sue. First problem, none of the photos are registered. And if you followed any of our stuff, you know that without registration, you can't file a suit. And that creates a problem, registering after the fact sometimes. The next problem was the invoice itself was undated, no address, no phone number in it.
I really wish I could tell you this is the first time that I had an invoice that didn't have a date or an address or a phone number. I have no idea why photographers and illustrators, not medical illustrators, they're much more precise. My guess is because it's not an email, which is automatically dated by your computer. People send out invoices and don't bother to put the date on. People have letterhead with no addresses. I couldn't make this up. I got a hard copy letter, snail mail, from a medical clinic that has 200 employees. And the letterhead just says, and I'm going to make this up, Urology Centers of North Dakota. No phone number, no hard address, no email address, nothing. Just the logo. That's it. That's their formal stationery that they're using to write back to a lawyer. Staggering, undated.
I spend a full day with my SVA class, my graduate class, on writing an invoice, because an invoice is your license. So it's important. And Ed and I have 10 things we say are required on just the front of your license, of your invoice, to have. And it's simple things like we said, who do they contact? Who are you contacting? Who's getting the invoice? You'd be surprised how many times people put in, they're dealing with a huge ad agency and they don't put the attention that it's going to. They send it to the entire agency. That invoice is going to float around for a while if you don't address it to the specific person who's supposed to process your invoice. Simple little mistakes. Other things too, like signing your invoice. It's your, and it may not seem you're only interested in getting the money to you, but later on, if there's an issue with the usage, which could be a lot of money and gets very emotional, photographers or artists, you want to make sure you have all these items listed. Well, on this issue in this invoice had 10 lines. That's all it was. It was very short, and there were no terms and conditions, something else we talk about all the time. You have to have these terms and conditions, which is usually the back of the invoice. Sending it electronically, it's just another page.
It's in our book. You could steal the one in our book.
Yeah, we have a plate for it. More than happy for you guys to use it. The usage that this person had on their invoice just said retail advertising and collateral. And a lot of guys write this down because they're told that by the agency, collateral use. And collateral, those terms, it basically means whatever you want to use it for.
Look up the term collateral in the dictionary, and collateral means everything else. So the ad agency or the client is saying, in that particular case, we're going to use it for everything except trade advertising.
Yeah. So in this case,
never, ever use the word collateral. Just cross it out.
So the photos in ads and storefronts of many retailers, and on hang tags, you buy a tag. The photographer, that's not what I wanted. And told that's exactly the usage license, and they paid for it. That's what your invoice said. Photographer said, that's not what I meant. Doesn't matter. There's another head slap by Ed that it's what you wrote is the only thing that exists. What you intended or what you meant doesn't matter. It has to be in writing. And that's why you hang on to those invoices. So we're going to move on to some of the AI stuff. And this is a case that everybody's been talking about. There's been other cases, actually some that have been filed this week by authors. This particular case, Anderson versus Stability AI, is by three authors, McKernan and Ortiz. They filed a case.
Jack, can I just, I am editorializing here. I'm just going to say this once and I won't repeat it. It's my opinion that the AI cases are in the wild, 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 wild west. There are no answers. The law will never catch up to this stuff in our lifetimes. So anybody who wants to give you hard and fast answers about AI, other than you can't copyright register a work created by AI. This is a gray area. Nobody knows what's going on, and the courts and the law will never catch up to the thieves, the hackers, and the companies. So whatever happens in any of these cases is totally unpredictable.
Thank you, optimist Ed Greenberg. Some things we can say about these cases, and one of the issues that we see with this case, these three artists filed a class action for unauthorized use of copyrighted images to train AI platforms such as Stability AI, Dream Studio, which is owned by Stability, Dream Up, which is owned by Deviant Art, and Midjourney, which is one that I use all the time. Only one of the has registered any of their work, and that was only 16 of her works. Now, if she did not register any of three didn't register, been thrown out on that by itself. So they hung on to this case by a thread because she had registered 16 of her images, and you know that she's produced thousands. But out of artists, only one of the artists registered work, and of her, she only registered. By the way, I just registered my last batch of 750 a week. I'm regularly at work. So the court, instead of throwing it out, they're allowing part of the case to proceed on the basis that her name appears in the database of haveibeentrained.com. So they're trying to find something to say, okay, we'll give you your day in court. The district court allowed a claim of direct copyright infringement to dismissed all their other claims. And we're going to explain what that is in just a second, including for vicarious infringement, but leave to amend, meaning they can refile. They're saying what you filed, there isn't enough here, but instead of throwing it out with what they say with prejudice, they're not doing that. They're saying we will allow you to refile a proper infringement. There's basically three types of direct infringement, contributory infringement, and vicarious infringement. I think we've covered this in another presentation. We're not going to go over it now, but there's three different types of infringements that you can file for.
Be careful whenever you're reading about a case in a magazine or any trade journal, even a legal trade journal. There's always more to the story, but in essence, any litigator will tell you that the judge is giving her another bite at the apple and is saying, when you come back here, if you refile, you better have a really, really much better case. How's that for grammar? A really, really much better case, or I'm throwing you and your lawyer out the window.
And basically, to rephrase what Ed just said, the court is now saying basically, fine, put up or shut up. Show us the evidence of copyright infringement. And this is the reason Ed and I have been saying some of these filings that we've seen, they're going to have a huge, and it has become a problem. And we'll explain a little bit more and show you some cases where this has come up. We noticed that the initial court, the plaintiffs, there were no exhibits showing the original work and the copy that was infringed, because that's copyright infringement. Is here's my picture, here's the infringement.
I have no explanation whatsoever for that. Every single one of our cases, without exception, on one side of the page that the judge sees is our shot or our client's image, and the other side of the page, side by side, is the ripoff, the infringement, the offending image, whatever you want to call it. How they, meaning the attorneys, did not put in what they're claiming the infringement is makes absolutely no sense. I can't conjure up an excuse other than it's an attorney who's never done this work before.
Yeah, and we've gone over many, many times that you cannot copyright a style. If that's the case, a lot of photographers would be sued by other photographers all over. People who've copied Ansel Adams or Richard Avedon, or in my case, I've studied Norman Rockwell early in my career. Part of my photography, I was known as a, quote, Norman Rockwell style photographer. I never copied any of his work. There's none of my pictures could you up next to any Rockwells and say, this is a copy of this. That's never happened, but the style is definitely there, and that's allowable.
Jack, how many times would you say that there are photographers out there who get a chance to shoot a celebrity and they're trying to do it like a Mark Seliger or Greg Gorman?
Yeah.
They're trying to give it that look.
Well, we go to a museum and look at what other artists are doing. We go to shows to see what other artists are doing. Every artist, be for a painter or illustrator, is influenced by other people's work. It's you don't work in a vacuum. Nobody does. And you look for inspiration, you look for things, and you do it your own way. You're not copying, but there's definitely an influence. And that's where the problem runs with AI, is the training is not copying. I've been hearing things where they say, well, it's cut and paste. It doesn't cut and paste. AI is looking for patterns And there's been already a couple countries that have come out and said that training is not copyright infringement. Japan specifically said that. Israel recently came out with that. The UK and I know the EU. There's some fine points, but they're basically saying the same thing. Show, and here's the copy. You can't tell me, well, it's used, that style or that look. There was one just this week. Sarah Silverman had her case against, which is Facebook, training their AI on her book, The Bedwetter. Hers was real interesting, but it was basically dismissed by the federal district judge in the Northern District of California past week for the same issue. While she can show that they used her book in training the AI, she can't come up with an example of what copied from her book. There's a little more into her case, into how they accessed that book.
Jack, I think you're right and wrong at the same time. I don't understand how any attorney with a single-digit IQ, and there are plenty of them, would bring this case. Here's a book on Gorbachev, okay? Now, I can tell a writer that I want to hire or work with and say, I want you to read this Pulitzer Prize-winning book. I like the style that it's written in, and I want to write a book about Bill Clinton in a similar type of style. That's not copyright infringement.
No, there's always been influences, and there's a big case with writers against AI that was just filed this week. But it's the same thing. Somebody told me early on, oh, you write a lot like Mark Twain, conversational style. And it's a very specific style of writing. And yeah, I do that type of writing. I never copy anything of Mark Twain's, but I understand what that style is. And that is something that an editor might tell you. Hey, look, we need this more in a style like this, pare it down, get it simpler, do more like Hemingway wrote, which is very simple and direct writing. Or they may want you to have more prose or more background where things lead up into things. Style is something that you can't sue against. And that's what a AI case coming up against. Now, that's not to say that you don't know what's going to happen with some cases. When things go to court, you just don't know what's going to happen or how things are going to be dealt with. Let me move on to this. This is also, if you see, this is just coming out this week. And this was pretty surprising. This was in the National Law Review, and a lot of
not to me, because before you go into it, Jack, I have been, we've done some articles on the Federal Trade Commission. The Federal Trade Commission is getting involved into all forms of modeling and photography because under this administration, the chains have been taken off. And if any advertising of any kind is possibly deceptive, misleading, or in any way not truthful, the FTC now has full sway to go after anybody and everybody, and they are doing it. And for me, as an attorney who represents creatives 99% of the time, it's great because a lot of the ads that we're suing over or websites frequently are in violation of Federal Trade Commission rules. Now, you can't sue, you don't have a personal right of action using the Federal Trade Commission, but the jury can take into consideration when they're awarding you money that this ad, which infringed on your registered image, also infringes on the Federal Trade Commission rules. And I put a witness on from the Federal Trade Commission that says, we are now going to pursue this doctor, dentist, whatever, and the jury, and juries don't like doctors to begin with in general, are going to, or more likely to award you more money.
Yeah, it's you do not want to deal with the Federal Trade Commission in your business. I will tell you, when I was on the board of PPA, and one of the things in PPA is that they cannot discuss fees among the members because that would be price fixing, and they avoid that because they do not want any investigation by the Federal Trade Commission, because if they start investigating you, and if you win, because what costs to defend yourself is
Astronomically.
it's backbreaking. So you never want to be involved with that. This is also on the same thing. I just like this visual. FTC veers wildly out of its lane to comment on copyright and artificial intelligence. So what happened is the office had a notice of where they're asking people to comment on artificial intelligence and copyright. And it was unusual that another agency, the FTC, would comment in this notice of inquiry. And what they're saying is they're going to be watching to see if there's any deception to consumers with artificial intelligence. So it's going to be interesting to see how the FTC is going to be artificial intelligence and copyright. It was raised a lot of when the FTC filed their comment.
The FTC has a big budget and orders to spend it all, and it's filling in, or it's serving to fill in the gaps between various states' attorney generals, copyright actions, and they have been very, very aggressive, and they're always in the background. And most I shouldn't say clients, most people and companies who are not sophisticated in advertising have absolutely no idea that the FTC is sticking its nose into everything. In all the cases where I brought them in, I would say maybe two of the attorneys were aware of an FTC problem before I alerted them to it. All the others, and these are attorneys, had no clue. They assumed it was a copyright case, pure and simple.
So here's one that was interesting that just came up on my feed. The Ninth Circuit revives a choreography's lawsuit against Epic Games over a Fortnite emote, a certain dance step. And you might be asking, it's coming up to photographers and artists, because we do choreography, we don't do dance steps. But it was an interesting ruling, and well, it's not a ruling, but just a comment. And it's reading between the dance steps is what I'm calling it. In this particular case, they reverse a dismissal of a copyright infringement, holding that the district made a mistake and erred in its application of the substantial similarity in terms of the line between anime and choreography, and remanded for further proceedings. Meaning,
in plain English, they're saying the lower court made a mistake, and you guys can go ahead with this case.
And
keep going.
The thing that interested me is the question was, initially the court said that the amount was too short and a small component of the original work, and the Ninth Circuit said that while is copying, meaning the amount of copying, may not be actionable, there is no bright line rule regarding the smallest protectable quantum of expression. As the court observes, short does not always equate to simple. And this is something we've talked about, where people say, it's just a small little thing. It doesn't matter. A small little thing could be very, very, very important in a copyright case. It's not
let me use the example
Go ahead.
Let me use the example that I always use. There's a photograph of me in a book with the Empire State Building behind me. My face takes up less than 5% of the photograph. If someone were to substitute or Photoshop Ronald Reagan's face or Taylor Swift's face into my face, they would only be changing, quote unquote, 5% of the geographic area of the photo, and they would completely and 100% change the meaning, message, and the photography by only changing 5% of the pixels. So when the reference comes to de minimis means, and there's no bright line, very, very, very tiny amount, so small that it's not worth anybody's time. It didn't affect the greater work, whether it's a movie or a book, and it's so small, we're not going to waste our time on it.
Yeah. And we're not going to waste any more time on this. The Supreme Court is looking at a damage period. And this was something that really raised Ed's eyebrows, and he pointed out to me that if a photographer damages for a period of infringement beyond the 3 years in copyright cases. So I brought a case today because I just found out about it. And this infringement's been going for 6, 7, 8 years. Can I look at damages going back that far, or am I limited to just the 3-year look back statute of limitations? So Ed, do you talk about this?
Well, yeah, I was a little bit surprised, but it's a common occurrence. My favorite case on this doesn't involve a photographer; it involves a model where they intentionally, in New York State, you have 1 year to sue if you're a model and your use is in commercial or trade is unauthorized, and a company printed up a box and put it in one store at the New York Canadian border. And so no one really saw it. And we found out about it about a month after the statute had run out of time, because now it was in CVS and Rite Aid and all the other stores. And the judge ruled that the model had gotten screwed, that the law was written badly, but it had been up for a year. And the fact that she, the model, nor me, nor anybody else was likely to go to this one drugstore in this town of 200 people in New York State didn't matter. Now the courts are going the other way with copyright, and they're saying, wait a minute, if this has been running for a long time, we're going to look for some excuses. Now, if the photographer watches NFL football religiously, and this is my case, well, was my case, and my client appears in an ad for 2 years in every single NFL game, local, national, regional. She appeared in every game for Toyota. If the photographer or the model was an NFL fan, she had no reasonable basis to say, well, I didn't see it for 3 years, or I didn't see it for a year, as opposed to one billboard outside of Las Vegas airport, and the photographer lives and works in Ireland. Then he has no reasonable way of knowing that it's for sale in the United States, or on, I should say, on a billboard in Las Vegas.
We're winding down on this. This is the first one. We really haven't had a lot of questions, which I'm very surprised. Usually we have a lot of questions from people. That's why we do it as a Q&A&Q. But I'm going to finish up on two things. This was something I just added in. And this was a friend of mine posted this on his Facebook page, and I haven't had time to call him, ask if I could use his name, but I'll give you the information. And it's a stock photography math today. Ed and I have been saying for quite a while that stock photography has basically died a while ago, but this one really sort of puts I think one of the final nails in the coffin, where there was a stock sale of a photo abroad for $10, which in itself is very unusual. Not unusual these days. It was 10 years ago, this would be very unusual, but stock sale for a photo for $10. So it was simple solution, no problem. There was a sub-agent, because it was in Europe, took 60% of the fee, because that's what they get. So that leaves $4 to the photographer. Now, a photographer had another agent, not the agent, the sub-agent takes their percentage, the agent takes their 60%. That left $1.06 to the photographer, which is bad enough as it is. But wait, there's more. Excuse me. There's bank transfer fees because it's abroad to get into his account. So it's $1 for each end of the transfer. It comes to $2. So a $10 stock costs the photographer 60 cents of his pocket. So it's the old joke. Well, how do you stay in business this way? Said, I'll make it up in volume. This is just the state of stock photography these days. And that's why we've been telling people to avoid it, basically. I don't know anybody really.
Do it on your own. License your own stock photography. Do it yourself.
That's where people are making money. Yeah.
If you gross a third as much as a stock agency or a quarter as much as a stock agency might gross, you will net far more money. You will control the pricing, the usage, and I don't know of any of my clients who have anything with any stock agencies anymore. And I won't do a stock. If someone comes in and wants me to go over a contract with a stock photography company, I won't do it. I turn them down.
Yeah.
I won't take the money.
Well, we've come to the end of our hour. I have one more little thing, which you know, this in is next month, December 20th. I am doing a presentation on the AI era, opportunities and possibilities. And this is not with Ed. This is with Apikshika Argawal, and I've done other lectures with her before. Her image on the left, and my water, can't quite see it here, and building on the right. But we'll be going over a lot of different things on AI for artists today, which I think people will find interesting. Let's see, I can't find this stop share. There we go. And so, Ed, that brings us to the end of another hour. We haven't really had any questions, which I think is the first time. Derek, did you get anything?
First time ever. No,
Yeah.
Nothing came through. First time ever. That means you guys were that thorough.
We were clear.
Thank you.
Sick.
We were clear.
Wow, look at you guys are getting more and more polished.
What if? No,
I'm
not
sorry?
a single one.
Not
That's
it.
good. It shows a more sophisticated audience.
That's it. They're learning little by little.
Yes.
Well, it is amazing that we keep saying the same over and over again. I would say that it's all settling in, except when I go online on some of the social media, I would say it's not settling in. I see the same issues, the same problems, the same things. And so that's why our logo on our blog is me and Ed in blue face, because we talk about these things until we're blue in the face, over and over and over again. But we do want to thank B&H for use of the space and letting us get some of these words.
No buffet.
For you didn't see what I got.
Swag bag.
Don't tell him.
They're just down. They're just across on the Sun line, the 7 subway from my house.
Here, I got some some ramen over here. Next time we'll have the buffet next time.
Yeah.
You guys send in your recommendations. We'll make it happen.
Oh, that's easy.
Oh, and somebody just wrote here, please don't take this as we are. I love when you're on. Thank you, Elizabeth. We appreciate it. It is always nice to hear from people.
Is that someone who wants to send us a check?
No.
Oh.
A smart person.
Tips accepted.
There you go. I'm surprised we didn't. Usually we'll at least get one like a situational. You know, and like
I'll give you a good situational I'm a cigar smoker, and someone called me up 2 or 3 years ago to do a publishing contract. The publishing contract provided that the books be printed in China. And I said, I will not do this contract. You cannot pay me. I don't want a consultation. You cannot sign a contract allowing the books to be printed in China. The author was from England. I sent him to an English attorney and never heard from him again. And 3 weeks ago, he told me that he used the attorney. The book is doing extremely well. It's printed in the UK. And he sent me a $500 box of illegal Cuban cigars. And I told him it was like Christmas Day. I would not take your money. And the books were printed in England so that they are not ripped off. So the last little tip, apropos of nothing we've done today, is don't let anything you do get printed, made, reproduced in China, because you will get ripped off and you will have no redress.
Well, if you get busted for your cigars, Ed, I know a good lawyer to defend you.
It's done legally.
I heard nothing.
Yeah, I heard nothing. I know nothing.
I know nothing.
Especially if the cigar comes in the mail to me. Right.
Danny, wipe this recording from the website.
Well, you know, there are guys who hang out at the bars at South Beach, and they tell you this is a fake Cuban cigar, but it tastes exactly the same. They're $35 a piece. Is it a crime? No. Because they're telling people it's a fake Cuban cigars, and these guys are so drunk and so ready to impress that they're stupid enough to pay $35 for something they're told is fake.
Wow.
One of my favorite signs was in Kusa, Turkey. There was, all the ships and everything get off, and there's a lot of tourists, and there was a big souvenir stand, and in big, huge letters over the top, it said, "You mind fake watches?"
Yeah.
It's
gotta love it.
Perfectly legal. Do with handbags all the time. Fake handbags.
I'm in the wrong business. I gotta start peddling fake merchandise.
well, I don't smoke cigars. Doesn't matter to me. All right, well,
gentlemen, yeah, thank you as always.
A pleasure.
Jack, you want to close us out? Take us out.
Take us out. Well, when you say gentlemen, it threw me off because you're making a real assumption there. Thanks again for use. And if people want to contact us with questions, we're always welcome for it. And we'll see you at the next go around, number 17.
There you go. Thank you, everybody, for tuning in. That's it.
Bye-bye.
Wraps up another edition of the V&H Virtual Event Space.
Bye-bye.
Catch y'all next time.
Bye-bye.
Bye-bye.
Bye-bye.